Limitation Act. Limitation Act 1963. Name itself suggests this is an act which put a limitation. Puts a what? Limitation. Let us understand the concept of limitation act with the help of an example. Help of what? Example. Let's say there are two persons, Mr. X, Miss Y. Who? Miss Y. Miss Y is in need of money. Who is in need of money? Mr. Y is in, not Mr. Y. Be specific with the gender. Miss Y, she is in need of money. She approaches her friend. Who is the friend here? X. She says, Mr. X, my ex friend. Did I say anything wrong? What is wrong here? Friend. Name is X. Correct, right? She says, my friend, my dear good friend, a friend in need is friend indeed. मुझे कुछ चाहिए. He says, क्या चाहिए रे तेरे को? She says, मुझे पैसा चाहिए. क्या चाहिए? पैसा. ನನಗೆ ದುಡ್ಡು ಬೇಕು. ನನಗೆ ಡಬ್ಬು ಕಾవాలి. Madam, madam. Okay. He says, I'll give. Don't worry. She says, please don't think bad that I'm asking money from you. I have a funds to receive. I'm in a difficult situation. I have too much of cash in my account. The only problem is the liquidity crunch. I have money, man. Like, don't think I'm poor girl that I'm coming and asking money from you. I have so much of money. Just, liquidity crunch. Please lend me some amount of money. I will return within 15 days of time. How many days of time? 15 days. Papa boy है, obviously kind-hearted persons. What he thought? अरे भाई oh. She request X to ask, request to what? Request to lend a loan of how much? 3 lakh rupees. How much? 3 lakh. Papa boy says yes, kind-hearted person. Because he is kind-hearted person, he is giving a loan. Giving a what? Loan. क्या दिया? Go. Yes. Yaru. X. Yarige. Y. Who. X. Who. To whom? Why? Loan दिया. कितना दिया? 3 lakh. How much? 3 lakh. And what date? Today's date. What is the date today? 9th of January 2026. Then the girl immediately said, friend, my dear friend, thank you very much. I promise to repay. Hello, I promise to repay your debt with what? Interest. With what? With the interest of 11% per annum. For what? Annum. Within 3 months. Don't worry, just give me how many months time? 3 months. I will return money like this with interest. With what? Interest. Boy is happy that he helps somebody. Help what? Somebody. But I no. Now 1 month over. On the thing 2 months over. 3 months over, the due date comes, the boy is eagerly waiting whether she will keep her promise or not. On the due date, he is waiting. He waits till the evening time. He has not received the fund. He calls her. She is not attending the call. Hmm? Now he got frustrated and he calls her again and again, and she's not answering the what? Call. Papa, he's like worried. It's hard and money, 3 lakh rupees. Nobody gives 3 lakh rupees at free of cost, right? ऐसा कमाने में थोड़ा मुश्किल लगता है, hard लगता है, correct, right? Nobody gives even a single rupee at free of cost, correct? No. So every penny comes with what? Hard work. He calls her and says, please give my money. She says, hey, I'll give, right? As if you have given so much of money. It's just how much? 3 lakh. ಕೊಡ್ತೀನಿ ವಾಪಸ್ ಎಲ್ಲಿ ಹೋಗ್ಬಿಡಲ್ಲ. Will not run away. I'm here only. I'm staying in Bangalore only. I'm staying in Bangalore since many years. You will not run away with your money. You will return. Just wait. He's like, I can't wait, ma'am. I have a commitment to keep, so please give it back. She's like, hey, wait. Give it back. ज्यादा मत बोलने का. धक्का मुक्की नहीं करने का. I don't know what is that. I just got that word somewhere. That Hindustani bahu. Some Hindustani bahu करके. Raj, not movie. That one fellow is there, na? Okay, ठीक है, अरे let's focus on the exam. Let's focus on the example, guys. What happened? How many months time? 3 months. Now tell me, did she default in the repayment of money? Tell me, what is the last date for the payment of debt? हाँ 3 months मतलब डेट बोलो भाई 9th April 2026. Any doubt? Jan to February 1 month. February to March 2 months. March to April 3 months. 3 months हो गया but उन्हें default कर लिया. क्या कर लिया? Default. Is it a criminal offense or civil offense? Because at the time of borrowing the loan, she had an intention to repay. What if she did not have an intention to repay it back? Then it will be what? Offense. What? Cheating. Cheating करता है तो no, because he has taken the consent of other person now by making a false promise. Fraudulently, you have taken the consent of other person. Vijay Mallya case. Understood? Clear? Civil case. Now, what X can do? Tell me what X can do. Can he file a case? But he is a kind-hearted person. What person? He has a right to file a case. Nobody should talk. Right to file a suit because there is a cause of action. Well, what of action? What is the cause of action here? Default by Y in the repayment of debt. That is the date on which cause of action arises. Till that time, did he had a right to file a case against her? No. Right tha, but right to file a suit nahi tha. Once she defaults, what will arise? Cause of action. Cause of what? Action. He has a right to file a suit, but he's a kind-hearted person. He waited. He thought she is in trouble. She might be in trouble. She might be in difficulties. So Papa is somehow adjust with his lifestyle. He eat in footpath. He eat in street. He is suffering, but still because he don't want the other person to suffer, he is ignoring all his problem and somehow he is surviving. He waits for 1 year, waits for 2 years, waits for 3 years, waits for 4 years. After 5 years, he meets that lady in a shopping complex. She's wearing expensive jewelries, branded clothes. Wait, do not ask single question about evidence. But asking question about ಅವನೇನ್ ಮಾಡ್ತಿರ್ತಾನೆ ಸರ್ ಏನು ಮಾಡ್ತಾ ಇರ್ತಾನೆ ರೈಟ್ I'll come to that point. She is wearing expensive jewelries, expensive clothes, expensive hairstyle, expensive. But she has done coloring and all. Coloring, expensive eyelashes, expensive foundation, expensive costumes, expensive makeup, an expensive husband, an expensive kid. In the sense, he is also wearing expensive things. How not to समझ लो बात. Are you guys clear with this? He saw all these incidents and he got hurt, deeply hurt. He wished good things for that lady, even though he was suffering and even though he was going through so many bad things. He saw this and he felt very bad. He He had an opportunity to get married, but he has not even got married. But this lady, with his money, she got married. He's living a life, dream, dream life. He felt bad. Now he's like, from today onwards, I'll not be a good person. Change. I'll drag her to the court. Drag her to the what? Court. Immediately prepares a petition. Prepares a what? Petition. What petition? A suit. He prepares a what? Suit. He prepares a plaint. Prepares a what? Plaint. After how many years? 5 years means how many years? Like 9th of April 2031. Am I correct? On this date, he go to the court, sir, I'm an innocent fellow, sir. This lady has taken money from me. I have a contract with her, sir. They go contract, and she has refused to make the payment, and I want my money back with interest, sir. Dekho, sir. Please, madad karo, sir. Help me. You are a judge. You are a symbol of justice. I need you to interfere in this and help me in this. Please, help. Court says, court says exactly. Court says, get out, you lazy fellow. Vigilantibus, non dormantibus. What is the principle? Vigilantibus, non dormantibus. Dormantibus means what? Court assist a person who is vigilant and careful, not the one who sleeps over his right. You had a right to file a suit. You, Mr. X, you had a right to file a case. Right to what? File a case. And you did not file a case. And you took how many years of time? 5 years of time. Why were you waiting for 5 years of time? I can't help you. Go back. Take this your case files. I can't take your case. Is this action of the court justified or not justified? Because in the interest of the justice or in the interest of the public policy, there should be an end to disputes. You cannot dispute an incident or you cannot dispute a right whenever you want. It's a civil case. What case? Because it is a civil case, the law provides limitation in the interest of justice. So if you have a right, be vigilant. Enforce your right as early as possible. As early as what? And Limitation Act prescribes the time limit. Which act? Limitation Act. There is a law which is made by the Parliament and the state laws. State also make what? Laws for the respect to state legislations, which provides the time limit. What limit? To file a suit, or to prepare an appeal, or to make an application. If you want to file a suit to enforce your right, or if you want to file an appeal against the lower court orders, or if you want to make a petition for seeking approvals, you go to the court within the prescribed time limit as per the Limitation Act. Then only the court will take your case. If not, the court will not take your case because it is barred by which act? Limitation Act. Which act? And as per Limitation Act, for the recovery of debt, what is the limitation period? 3 years. How many years? So the last date, bro, the last date by which he could file a case as per which act? Limitation Act. Which act? You guys tell me what is the last date by which he could have filed a case? 9th of April 2027. Case number 77. 3 years, 2029. That is the last date. If you go on 9th of April, will court take case? Yes. Oh, on time. Oh. Chalega. But if you go on 10th of April, sorry, bhai, I can't help you. Chale because it is what word? Time bar. What word? What the purpose of the Limitation Act? And it is based on the principle called as what? Vigilantibus non dormantibus. Means court will assist a person who is vigilant and active, not the one who sleeps over his right. Dormantibus. Vigilant, active. Court assists whom? One who is vigilant and not the one who is dormant. It is also based on the public policy that in the interest of justice there should be end to litigation. End to the what? You cannot litigate whenever you want. Aresa, no. Shall I give one more example? Shall I give one more example? Shall I give one more example? That will make you guys understand why this law is important. Okay? Let's say Husband and a wife. Who? Married. I'm giving clarity. What if you guys say, like, sir, are they married or not? What if they ask, what if you guys ask the question, sir, are they married or not? Correct, right? Married, husband and a wife. Now they have some disputes. Girl want divorce because she has a boyfriend. I don't know. Okay, husband has a girlfriend. Okay, both of them have a boyfriend and equality. Okay, she filed a petition, but still the boy wants to live with the lady only. Like he wants that man. No, that is why. Okay, she filed a petition for divorce. Who filed a petition for divorce? Lady. She got divorced, but husband still wants to live with her. But she don't want to live with him because she want to get married to that boy. In the family court, what court? Granted divorce. बोला कि okay, ले लो divorce. जाओ. Can the husband go for an appeal? Can he go to an appeal to the higher court, challenging the order of the lower court? Yes. He can always challenge the divorce. Within how many days? Do you think there should be a limitation for going for an appeal? She can't wait for the lifetime, right? To decide the case and finality. There should be a time limit. So if you don't go for an appeal within this time limit, appeal time is over. She can get married immediately. So there should be an end to litigation. End to the what? Litigations. Got it? The purpose of having which act? Limitation Act. Which act? Yes or no? Limitation Act provides what limit? Time limit. What limit? What limit? Time limit. What limit? What limit? Time limit. It is an punishable offense. You can file a case against him. Assault. Yeah, don't kill him. It is also punishable offense. This is also punishable offense. Threat. Hmm? Are you guys clear with this, everybody? Are you no? Limitation Act provides what limit? अरे बोलो what limit? Time limit. To file a what? Suit. Prefer a what? Appeal. To make a what? Application. Are you guys observing the words here? To file a suit. Prefer an appeal. To make an application. बोलो. To file a suit. To make a petition. To prefer an appeal. Prefer what? Appeal. Is there a time limit? Yes. All three are different. Suit is different. Appeal is different. Application is different. When you want approval of the court, what of the court? I make an application. For example, I make an application for bail. Bail application. What application? Have you heard bail application or bail suit? Application is to seek the permission of the court during the pendency of the proceedings. And application can be filed. Applications can be filed either before the suit or after the suit. Getting it? But suit can be filed by the parties to the contract. Parties to the what? Contract. So appeal is different, suit is different, application is different. For example, I want to file a case as a pauper, insolvent, indigent person. मेरा पास पैसा नहीं है to pay the court fees. मेरा तो दुड्डिला court fees कम कटली के. And अंतने sir, judge साहब, please give me a permission to file a case as a what? Insolvent. I'll make an application for that. What for that? Application for that. So application is different, appeal is different, and suit is different. And there is a time limit for what? All the three things. Even for certain offences, we have a time limit. We discussed under the what? BNSS, Bharatiya Nagarik Suraksha Sanhita. In this chapter, we are going to discuss what is the Limitation Act, what it prohibits, then what are the provision with respect to calculation of limitation period. What period? Limitation period. If you guys are ready, I will start the chapter. Are you guys ready? One interesting chapter and it has a weightage of 5 marks in the examinations. How many marks? 5 marks. Are you ready for this? Yes or no? Before I start this one, I want to ask questions to you guys. Does Limitation Act bars the remedy in the court of law, or is it destroying the right of a person? When you go to the court, is the court saying you are not having a right? Or the court is saying I cannot take the case, I cannot give a remedy in the court of law? That means it is only bar the what? Remedy in the court of law. It does not extinguish the right. Limitation Act and sit in a different place. Limitation Act bars only the remedy in the court of law. It does not extinguish the right. Limitation Act does not extinguish a right where there is one, does not create a right where there is none. It only bars the remedy in the court of law. What is it? Limitation Act does not extinguish a right. Extinguish a what? Right where there is one. Does not create a right where there is none. It only bars the remedy in the court of law after certain period of time. That's it. It is not a substantive law. It is not creating any right upon any person, or it is not extinguishing any right. It says this is the time limit. If you don't go within the time limit, you cannot seek the remedy from the court of law. That is what called as, and what is the purpose of which act? Limitation. Which act? And it is a mandatory provision, means the court should take into consideration the limitation period for every suit. Even if other person is not claiming it, you both are okay with this. He is filing a case after how many years? 3 years. You are okay with this. But if court is not okay, not okay. That's what. Go for settlement. Court should take the cognizance of limitation. Cognizance of what? Limitation. Even if the defense does not pleads it, does not claims it as a defense. It is limitation. It is time bar. We can claim a defense, right? Saying that it is time bar. You are not claiming it. Still, the court should not take the cognizance of an offense if it is what bar? Time bar. What bar? So Limitation Act provisions are mandatory in nature. What in nature? Mandatory in nature. But there is also twist over there. I'll come to the twist. Wait. Should I go to the material and discuss the twist, or can I discuss directly? Are you guys able to understand what I'm discussing? Listen. What if, tell me, section number, the Limitation Act, does it creates a right? Limitation Act, does it create a right upon any person? Does it extinguish the right of any person? Does it extinguish the right of any person? No. It only bars the what? Remedy in the court of what? What if you could enforce that right outside the court process? Can you still enforce that right? Yes. The best example for this provision is section number 59 to 61. Section number what? Section number 59 to 61 of Indian Contract Act. Bolo? 1872. Which year? 1872 clearly provides that when a person owes several debts, what debts? देखो ना. Mr. X, who? Mr. X has given loan. Has given what? Loan. To whom? Why? Multiple loans. What loans? Multiple loans. एक लोन लिया था 1 लाख रुपीस का 1 लाख. Y ने लिया था 2 लाख. Is my Hindi good? Thank you very much. I wanted you to say this. Thank you. That means it is good. Yeah, that's what I know. 3 lakh rupees. अरे भाई हो गया. Am I disputing the fact what you said? No, right? Then don't please. Fourth one. I like peace. 4 lakh rupees. 1 lakh, 2 lakh, 3 lakh, 4 lakh. ठीक है? These are the things which were taken by whom? Mr. Y. at a multiple time. Okay. Out of these four debt, a time bar debt. What bar? Time bar. He has not repaid it and already 3 years over. Now, can X recover this 1 lakh rupees by filing a suit? Can he recover it by filing a suit against Y? Why no? Time bar. If he go to the court, court will not take his case. So no. That is a scenario. No. What if Y makes a payment? Who makes a payment? Y. Y makes payment now. Y makes a payment of let's say 50,000 rupees. How much? Saying that Mr. X, बहुत दिन के बाद, after a long time, I'm paying you the money below 50,000 rupees. Enjoy. He has not specified towards which debt he is paying. Neither is specifically mentioning it, nor is intention shows towards which debt he is making the payment. Just paid it. In that situation, law says the option goes to whom? Creditor. Generally, it is always as per whose intention? Debtor intention. If he says I'm paying towards second one, you should apply towards which one? Second one. Third one, third. Fourth one, fourth one. Fifth one, fifth one. When the debtor fails to indicate either by words or by conduct towards which debt he is making the payment, then the option goes to whom? Creditor, as per section number 60. Section 60 says the creditor can appropriate the money received towards any of the debt. What of the debt? Lawful debt. What debt? Is this lawful or unlawful? Lawful. It's time bar. What bar? Time bar. They can apply it towards any of the lawful debt, including what debt? Time bar debt. What debt? Can he apply? If you are a sane man or if you are a diligent man, you will apply this 50k towards which one? First one. You will say, I will apply this towards the first one. So remaining 50k is pending, which is time bar. I can't file a suit for this, and you can file a suit for remaining debt. So Limitation Act does not extinguish what? Right. It only bars the what? Remedy in the court of law. If you could still recover the money in some other ways, can you still recover it? Yes. I hope you guys conceptually clear with this. Yes or no? Understood? Does Limitation Act creates a right? Everybody creates a right? Extinguish the right? Only bars the what? Remedy in the court of law. Is it mandatory provision? Is court required to apply this provision even if the other person is not claiming it? Yes or no? Now let's think from one more situation point of view. It is mandatory for the court to not to take the case when it is time bound. What if the court takes the case and decides the case? What happens in that scenario? Let us discuss that scenario. What scenario? That scenario. What is the scenario here? Case is time bar. Court admits the case and decides the case. In that situation, what are the consequences? Is that decision valid or not valid? How many of you say it is valid? None of you. Very good. Decision. Either it is valid or not valid. Valid or what? Not valid. क्या होता है sir in this scenario? Again, Limitation Act does not grant jurisdiction to the court, does not take away jurisdiction of the court. What is jurisdiction? Power. If you do something without power, it is nullity. What is nullity? Void. It is never in existence. It is stillborn. Adu utte illa. It means it is void, ab initio, void from the beginning itself. What if you have a power, but you exercise that power in a wrongful manner? What manner? You have a right to hear a case, but hear that case in a wrongful way by admitting a time barred suit, and you decide the case. Is it a error of jurisdiction or exercise of jurisdiction without jurisdiction? Is it a wrongful application of jurisdiction or is it a non-decision without jurisdiction? Wrongful application of what? Jurisdiction. What application of jurisdiction? It means the decision is what? Questionable. Decision is what? It's a wrong decision. What decision? And whenever a decision is wrong, what is the remedy available to the aggrieved party? If a court gives a wrong judgment or a wrong decision based on wrong facts and wrong situation, you can go for what? Appeal, seek the legal remedy. What remedy? Within the what time? Prescribed time. What time? What if you don't seek the legal remedy within the what time? Prescribed time. What happens? Limitation Act applies. It is applied. What happens to decision now? I have given a decision. What decision? Wrong decision. मैंने गलत decision दिया. Wait, I'll come to that one. Now you have how many options? Two options. Because it is the wrong thing. What thing? Can you challenge it? Within the what time? Limitation time. If you challenge it, decision becomes what? Invalid. Because you are challenging it. What if you don't challenge it? Limitation period gets over. Decision becomes what? Absolute and final. You cannot challenge, you cannot say it is invalid. Yes or no? Because Limitation Act does not take away jurisdiction of the court. It only says don't do this. If you do that, it is a wrong thing. What thing? Wrong thing. And it can be questioned by the aggrieved party. If it is not questioned, decision is valid and final. What if court decides a criminal case? It's a civil court. What court? Everybody concentrate. What court? Decides a criminal case. What case? And you know what case? Is the decision valid or void? Criminal court deciding civil case or civil court deciding criminal case. Valid or void? Everybody valid or void? Because there is no jurisdiction. If I have jurisdiction, but if I exercise that jurisdiction in a wrongful manner, what manner? You challenge it, it's a right. You have a right to go for an appeal. If not, that decision it becomes valid, even if it is a wrongful one. Are you guys getting it? But if I don't have a power, jurisdiction, and if I decide something, the decision itself is not in existence. That is stillborn, it is void ab initio. Got it? So if a time bar debt is admitted, what is admitted? Time bar debt. And if the court decides it, it's a wrong decision. Can you still challenge it? Yes. Challenge, High Court says it is invalid. If you don't challenge it, within the what period? Limitation period. What period? Decision becomes valid even though it was done by exercising the jurisdiction in a what? Wrongful manner. What manner? Wrongful manner. They might ask question, practical question based. I hope you guys are conceptually clear with this. Yes or no? Because Limitation Act does not take away what? Jurisdiction. Take away the what? Jurisdiction of which court? Any of the court. It just imposes an obligation. Impose a what? Upon who? Court. So not to try a what? Suit. After what period? Limitation period. If the court tries it, what happens? Decision is what? Questionable. If it is not questioned, it becomes what? Final and binding. Final and what? Binding. Understood? What if court is not having jurisdiction? The decision itself is not in record. It is void ab initio. You can go to the court and after 10 years also. Because it was done without what? Jurisdiction. What if court does with jurisdiction but in a wrongful way? Hೀಗ್ ಮಾಡಬೇಕಿತ್ತು ಹೀಗ್ ಮಾಡಿದೆ. Challenge. If you don't challenge, it becomes absolute, final. Clear? Two important concepts. How many concepts? Two. What is the first concept? Limitation Act. Repeat. Does not create any right where there is none. Does not extinguish the right where there is one. It only provides time limit. Only provides what? Time limit. And it only bars the remedy in the court of law after the prescribed period of time. Are you clear with this? What's the act name? Limitation Act 1963. I want everyone to focus now. Last bench students, first bench students, CSR students, some other person students, please concentrate. Let's start. What is the chapter name? Lesson number? Lesson number 10 now. Are you? Uh-huh. दो तीन चैप्टर खत्म कर लिया ना, रिमूव सम 3 4 chapters, right? Lesson number 9. Lesson number what? 9. Law with respect to what? Limitation. Law with respect to what? Regulatory framework. What is the short title of the act? What is the short title of the act? Limitation Act. Which year, everybody? 1963. 1963. Extent, is it applicable to all of India? Yes. When the act came into force, on the date notified in the what gazette? Official. तुमको नहीं चाहिए, कब आया, कैसे आ गया, तुमको क्यों चाहिए भाई? हिस्ट्री कौन पढ़ाता? ठीक है, इंट्रोडक्शन. क्यूट, you should get scared so that you will remember. What does the first picture says? Remedy is what? Barred. Limitation Act only bars the what? Remedy. But it does not extinguish the right. Right is not extinguished. Only what is barred? Remedy is barred. Yes or no? Uh-huh. No, I can't. I can't. That is a creative. That's a creativity. I can't disclose that. I did it yesterday night. Like I spent some time on this. But you guys, trust me, you will remember it now. These two words you'll never forget now. What is the first word? Limitation Act bars only the what? Remedy. Does not extinguish the what? Right. This picture will stay forever in your mind. Listen. Let's discuss. Introduction. Does the question might come like this? Does the Limitation Act bar the remedy in the court of law, or does it extinguish the right? What is the answer? It only bars the remedy in law, does not extinguish the right. The law with respect to limitation is incorporated in which act? Limitation Act 1963. In the case of Bombay Dyeing and Manufacturing Company Limited versus State of Bombay, the Supreme Court held that limitation bars the remedy. Bars the what? Remedy in the court of law only when the period of limitation has expired, but it does not extinguish the right, that it cannot be enforced. By what process? Judicial process. That if a claim is satisfied, what is satisfied? Outside the court. What are the court? Same like this Indian Contract Act example. Is it still valid? Yes. You can enforce your right outside the court, right? Yes or no? Example, section number 59 to 61 of the Indian Contract Act. Section number 3, section number what? 3 of the Limitation Act provides that any suit, bolo, or everybody should answer. First one, any suit. Second one, appeal. Third one, application made beyond the what period? Shall not be entertained by whom? Court. Even if the plea of limitation is not raised by the whom? Defense. Even if the defense is not claiming it, still the court should not take the case. Section 3, section number what? 3, imposes an obligation upon the court not to try the case after the what period? Limitation period. Is it extinguishing the jurisdiction or imposing an obligation? Imposing a what? Because it is not taking away jurisdiction, just because it is imposing only a restriction. Only what? Restriction. If a court admits the case which is time barred and tries the case, decides the case, and if it is not set aside by challenging it within a what period? Prescribed period, decision becomes what? Final. What becomes final? Decision becomes final. They can ask practical question based on that. Continue. Thus, court can suo motu take a note of question of what? Limitation. The question whether a suit is barred by limitation should be decided on the facts as they stood on the date of what? Presentation of the plaint. Presentation of the what? Plaint. And the limitation is applicable. Everybody look here. Only look here. What are the words used here? Suit, appeal, suit, petition, applications. Correct, right? Suit for claiming the right. Petition to seek the permissions. Appeal to what? Go against the order of the lower courts. Order of the what? Lower courts. So limitation period is there for what? Both suit, appeal as well as application. Appeal as well as what? Any suit filed or application made or appeal preferred after the prescribed limitation period, the court should not try that suit, admit the appeal or application. Which section number impose that obligation? Section number 3. Section number what? 3. Bar of limitation. What of limitation? Bar of limitation. Section number क्या है? 3. Section number 3. Can you see this? What is this? Time, limitation, time. Arey, no. Stranger things. Yeah, these are also strange. Next one. Bar of limitation. Bar of what? Limitations. What is the section number? 3. Bar of limitation. What of limitation? Bar of limitation. Under how many goes here? 3. Section 3 deals with what? Bar of limitation. What of limitation? Bar of limitation. I don't know, but they are at bar. Simple as that. Yeah, what are you thinking? Logic, bar of what? Limitation. How many goes are there? 3. Section number 3 deals with bar of what? Limitation. Bar of what? Limitation. I've already explained these provisions. I want everyone to read this. They can ask question in the examination based on this. I'll not explain, just go through it. I've already explained it. पढ़ाई करो. Section 3 of the Act 1963 provides that any suit, appeal or application made beyond the prescribed period of limitation shall not be entertained by the court even if the plea of limitation has not been raised as a defense. The court is under obligation to dismiss. Obligation to what? Dismiss if a suit is filed beyond the time prescribed by the limitation act. These provisions of section 3 are mandatory and the court shall not proceed with the suit if it is barred by time. However, the effect of section number 3 is not to deprive the what? Court of its jurisdiction. This sentence is most important. Have I discussed this? Section 3 does not deprive the court of what? Jurisdiction. This court still have a power. It only imposes what? Obligation. Imposes what? Obligation. Therefore, decision of a court. What of a court? Allowing a suit which had been instituted after the period prescribed is not vitiated. What is vitiated? Not invalid for want of what? Jurisdiction. Want of what? It cannot be considered as nullity. Not be considered as what? Nullity. Only when you go to the higher court, it is declared as invalid, it becomes invalid. Correct, right? A decree passed. What passed? Decree passed in a time barred suit. What suit? Is not a nullity. Not a what? Nullity. Is that valid? Yes or no? Yes. If it is not challenged within the what time? Prescribed time. What time? Is that valid or not valid? Valid. And Limitation Act is also applicable for what suit? IBC, insolvency and bankruptcy cases. What cases? Insolvency and bankruptcy cases. Can you guys read about section number 3? Do section 3 take away the jurisdiction of the court? So if a decision is made or decision is given or judgment is given admitting a time barred suit, is it still valid unless it is what? Set aside by challenge. Limitation Act does not create a right, does not take away the right, does not deprive the court of jurisdiction. It only bars the remedy in the court of law after the period of what? Limitation. And which section number deal with? Section number what? 3. What is section number 3? Bar of limitation. Bar of what? Does it create the right? Does it create the right? No. Does it extinguish the right? Does it bar the remedy? Yes. Which section number deals with bar of limitation? 3. Clear with this? I have already advised you guys that I am going to use certain horror pictures. So make sure I'm already next one. ये भी interesting है. What is court? Closed. Court is closed. What is closed? Court is closed. Section number what? 4. Simple say simple provision है. If the prescribed period, what period? Of any suit, appeal, application expires on a day. Expires on a what? Day. When the court is closed. What is closed? And what is closed? Court is closed. The suit, appeal, application may be instituted, preferred, or made on the day when the court reopens. Simple, say simple. Today is the last date. On that last day itself, court is closed. Then the law says, don't worry, beta. You can file it when the court reopens. That is the last time, last day. Yeah? So, can I guys read one more time? If the prescribed period, what period? For what? Suit, appeal or application falls on the expires on the day on which the court is closed. The same thing can be filed, preferred or made on the date when the court reopens. Court what? Reopen. Section number क्या है? 4. Are you clear with this? Section number 5. Doctrine of sufficient cause. What cause? This doctrine of sufficient cause gives the discretionary power. What power? Discretionary power. To whom? To the court. To the what? Court. To extend the time limit in certain cases. Wherever the justice demands it. What demands it? Justice. It is not an absolute power of the court. It is not an absolute right of the accused party. It is a discretionary power. What power? Discretionary power of court. What do you mean by discretionary? Court may grant it, may not grant it, based on the interest of justice. Interest of what? Justice. There can be sufficient cause, but court may not give a what? Extension. Court cannot give what? Extension. Because if the justice could not be served. Nobody can claim section number 5 as a matter of right. What of right? And just because there was an extension given in one case, it doesn't mean you can claim the extension in other case also. Because it is a what power? Discretionary power. What power? If it is a matter of right, what of right? You can claim it. ಅವ್ರು ಕೊಟ್ಟಿದ್ರೆ ನನ್ಗೆ ಕೊಡಿ ಅಂತ ಕೇಳ್ಬೋದು. But if it is a discretionary power, it is a discretion of boot. Court. Court may grant extension, may not grant extension. Bro, may grant extension, may not grant extension. When court can grant extension if the person is having a sufficient cause. And what is a sufficient cause is a question of fact which will change from case to case basis. And this sufficient cause doctrine is applicable only for appeal. Only for what? Appeal, not for suit. Why? Because the limitation for suit is generally more longer period. 3 months, 6 months, 1 year, 2 years, 3 years, 10 years, 20 years, 30 years. Whereas for an appeal, for what? It starts from 10 days, 15 days, 30 days, 60 days. Max to max how many days? 90 days. That's it. More rarest of the rare cases. Because the limitations period for appeal is very less. And if a person could not prefer the appeal within the prescribed time because of some sufficient cause. What cause? Court may extend the time and can admit the suit. So not suit, appeal. Even after the expiry of what? Limitation period. What period? Limitation period. इसको बोलता है doctrine of what cause? Sufficient cause. Is it a discretionary power or a mandatory right? Discretion of court. Can a person claim this as a matter of right? No. Court may grant, may not. Only on what grounds? Sufficient. What if a person is having sufficient grounds? Can court still reject the appeal? Can court still reject the appeal? Yes or no? Perhaps second I was finding some similarities. Section number Section number what? Five. Doctrine of what cause? Sufficient cause. What cause? Sufficient cause. Are you guys clear with this? Give me an example for when court will not give extension even when the person is in having sufficient cause. First, I will give an example of sufficient cause. Example of what? Can you guys tell me what is that example by looking at this picture? Just tell me. She is the not dead. She is the daughter and he is the father. Is he dead or alive? Alive. And what she is doing? Ah, very good. How do you know all these things? Yeah, very good interpretation. She is taking care of what? Father, not after. He is alive. He is reading book. We are in the ghost era. Or they are alive. They are possessed. Okay, but they are human beings alive. We are applying this law to the ghosts also. Okay, listen. Now he got she got some order against her. She had a right to file an appeal. So not right to file, right to prefer appeal. Prefer what? Appeal. During that time, her father suffering some injuries, and she is taking care of her father. Because of that, she could not file. She could not prefer the appeal within the prescribed time. Why? Because she is taking care of her father. No, she can't leave her father. He is about to die. Who will think about case when maybe भूतों को भी भूत का भी इमोशंस होता है हर इमोशन के पीछे एक इमोशन होता है मतलब हर सॉरी नॉट इमोशन इट इज हर रिलेशनशिप में एक इमोशन होता है अरे होता है भाई we make mistakes you are human beings yes or no yes that mistake was intentional are you guys clear with the concept here what is the concept here does she has a sufficient cause to claim the extension of time because she was taking care of the ailing father, the deceased, like the injured father. Correct, right? Yes or no? Can she go? Let's say if she go after 60 days, even though time limit was 10 days, will court take the case? Yes, court take. No, acha lady, like you are such a good daughter, taking care of your father. Don't worry, I will extend the time. Don't worry, I'll take care. Can court extend? Discretionary power plus there is a what cause? Sufficient cause. What cause? One more booth. Let's give one more example. Take a listen. Where extension is not granted even though she has what cause? Sufficient cause. Should I write and explain or should I tell explain AC? Listen. Um, a girl, a booth girl, she filed a petition for divorce from her booth husband. Divorce granted. The husband is in shock, pain. He is in coma. He bury himself and stay underground for 2 years. How many years? 2 years. Because he is in coma. Coma, yeah, shock, mental illness. For how many years? 2 years. So he has a right to file an appeal. Right to file a what? Appeal. Within 1 month. How many months? 1 month. Now this female booth wait for 1 month. Waits for what? After 1 month, what she does? Get married. Another booth. Now this booth who was in shock coma comes out after 2 months. After how many months? 2 months. Okay, let's say 2 months. Let's make it logical. 2 months. And he goes to the court and says, sir, please, sir, मुझे मेरा पत्नी चाहिए. I want my wife back. Please declare this Divorce as invalid. Why? Because it is taken on a what? Invalid grounds, sir. Please declare it, sir. And the court says, where were you this many days? Sir, I was in shock, sir. Coma, sir. I had only one wife and she gave divorce to me and I was in shock, sir. Please, sir. And I have a sufficient cause. What cause? Sir, when I was lacking mental ability, how will I file a appeal, sir? Please, sir, take this into consideration. Court says, I understand your emotions, feelings. हर emotions के पीछे एक emotion होता है, but I can't take your case. Why? Because it is time barred. Even though you are having sufficient cause, I cannot serve any justice because she's already married to someone. Even she has done the right thing. What will be the consequences if I admit your appeal now? What I will do? She's already married to someone. He has a sufficient cause, but still, what is not granted here? Extension is not granted. So is it mandatory for the court to grant extension in every cases? No. It's a discretionary power in the interest of justice. Interest of what? Justice. I hope you guys are clear with the concept of doctrine of sufficient cause. What cause? Section number क्या है? 5. Is it applicable for suit? Is it applicable for suit? No. Only for what? Appeal. Because appeal के लिए कितना time है? Less period of time. For suit, there is no concept of what? Sufficient cause. What cause? There cannot be any extension given. Can you guys go to the points, please? Let's go to the point. Concentrate, everybody. First point. Section 5 of the Limitation Act 1963 allows the extension of prescribed period in the certain cases on sufficient cause being shown for. Section 5 applies to appeal and applications. Most important, not for the suits. Not for the what? Suits. Why? Because the limitation period for suit generally is what? Ranges from 3 to 12 years. Whereas appeal and application typically have shorter time limit. That is the reason only for appeal and applications there is an extension of time period. Extension of what period? The party applying for condonation of delay. What of delay? Should satisfy the court for not making an appeal or application within the what time? Prescribed time. He had a what cause? Sufficient cause. इसको prove करना पड़ेगा that he has a sufficient cause. The quasi-judicial tribunals, labor courts, executive authorities have no power to extend the what period? Limitation period. It's only for the court. Only for the what? The doctrine of sufficient cause is applicable only for the limited provisions before the court. Before the what? Court. Is it mandatory provisions or discretionary provision? Everybody what provision? Discretionary provisions. And the following are held to be what cause? Sufficient cause. What cause? Examples. The following were held to be what causes? Sufficient cause. What is the first one? If the appellant or the counsel was misled by the wrong practice and information of whom? High Court itself. What court itself? Because of the wrong advice of High Court, a wrong practice of the High Court, you could not prepare an appeal to which court? Supreme Court. Is that a sufficient cause to seek extension in the Supreme Court? Yes. Second one. In certain cases, what cases? A mistake by counsel may be considered as a what? Ground for condoning the delay. Means if an advocate make mistake because of which he could not file the appeal within the prescribed time, that can be considered as what cause? Sufficient cause. Not in all cases, only in the exceptional cases. What cases? Third one, wrong advice by whom? Fourth one, imprisonment of the party. Are there what? Serious illness. ಅವನಿಗೆ ಹುಷಾರಿರಲಿಲ್ಲ. He was under serious illness or he was under jail. That can be taken into consideration for the purpose of extension of the time limit for the purpose of filing an appeal or application. Fifth one, delay caused by the time taken to obtain the what copies? Certified copies. What copies? To take the certified copies from the court, there was a delay. There was a what? Delay. There was a what? Delay. Will you include the delay? No, because it is out of your control. Last one. Ailment father. What is ailment father? Our booth ka example. The ailment father was under severe injuries. The booth was taking care of the father. That was held to be a sufficient cause. What cause? Sufficient cause. And yes or no? What if you're a like insolvent person? You didn't have money to go for an appeal. Will that be considered a sufficient cause? Yes. If you're insolvent. Again, it is discretionary. Depends upon the case to case basis. Who will decide this? Court will decide. having regard to the what? Facts as well as the honesty of the person who is claiming it. Honesty of the person who is what? Claiming it. Alright, Bhumi, yes or no? Next one, next one, next one, next one. Are you studying or what? Are you studying from the book? Wow, very good. Like what? Hmm. Yeah. Can you guys read the example? Not sufficient cause. Case law. Darshan Singh case law. Can you guys read Darshan Singh case law? In Darshan Singh case, the Rajasthan High Court held that the non-availability of the case filed to state council or panel of lawyer is not a sufficient ground for condoning in what? Inordinate delay. What delay? And you are trying to find the short notes, is it? 4, 5, what is 3? Bara, 4, closure of 2, 5, option are sufficient for. It's only applicable for what? Appeals and application, not for the suits. That too only when there is sufficient cause. We have discussed the examples for the sufficient cause, and we also discussed why there is only extensions for appeal and applications, not for the suits. Are we clear with this, everybody? Yes. Yes, sir. Case law, can you guys read this case law? This is your there in your material also. Based on this, they can ask questions in the examination. Just go to the case study. कदम कदम बढ़ाएंगे साथ में हम गाएंगे ये जिंदगी काम का. Wow. For the first time, so much of silence in the class because I'm quiet. Hmm. Are you guys reading it? First point is clear. First point of time. Second point. You want me to explain? The law of limitation is based on what policy? Public policy, which requires that there should be end to what? Litigation. वही तो मैंने बोला ना. I use this word. There should be end to the what? Litigation in the interest of what? Justice. Interest of what? Justice. Forfeiting the right to a remedy rather than the right itself. That is what you have discussed. Does it forfeit the right to remedy or right itself? Right to what? Remedy, not the right. Right remains with you only. You are just saying we will not get the remedy. Understood? Second one. A right or remedy that has not been exercised or availed for a long period must come to an end or ceases to exist after what? Certain period of time. The provision of Limitation Act must be construed differently. Must be construed what? Differently. For instance, section number 3 must be construed strictly. Must be what? Strictly. It's a mandatory provision. Section number 5 must be construed what? Liberal. There are some different type of questions. They'll say section 3 must be construed strictly. Section 5 must be construed liberally. Explain. Nothing but you have to write about section number 3, section number 5. These facts. Don't we get confused in the examinations? Yes or no? Subject is not difficult. Then third one. While advancing substantial justice, what justice? A liberal or justice-oriented approach may be kept in mind. However, it can't be used to defeat the what law? Substantive law. What law? You have to keep a liberal mindset to it. Enforce or give the justice to a person, but you cannot overreach it. You cannot just use it every case and it will keep extend the time for what? Every now and then. Clear? Courts are empowered to exercise discretion to condone the delay. Condone the what? Delay. If a sufficient cause is explained. However, such a power is discretionary in nature and may not be exercised even when what cause is established? Sufficient cause. There's so many examples there that reverse example. Thank you, sir. Next one. Merely, merely some persons obtain relief. Obtain what? Relief in similar matter. What matter? It doesn't mean that others are also entitled to what benefit? Same benefit. Don't come with comparison. ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ರೆ ನನಗೇನು ಕೊಡಲ್ಲ. Don't compare. Don't compare and ask remedies. If you have a right, you come and ask. Simple like that. ಅವ್ರು ಮಾಡ್ತಾ ಇದಾರೆ ಏನಕ್ಕೆ ನೀವು ಮಾಡಲ್ಲ? Don't. ಸರ್ ಅವ್ರು ಬ್ರೇಕ್ ಕೊಡ್ತಾರೆ ಸರ್, ನೀವೇನೆ ಕೊಡಲ್ಲ ಸರ್ ಬ್ರೇಕ್. Wrong comparisons. You understood what I said, right? You should find what you have lost, where you have lost. That makes sense. That is logically relevant, but not may not be legally relevant. But you should always go with what is legally relevant. Next one. Next one. Merits of the case are not required to be considered for what? Condoning the delay. Oh, this is what most important. क्या है sir? Merits. See, why I want you guys to pay attention for every word, because every word is a different concepts. Based on that word, they can ask question in the examination. See, मुझे पता है. Wait uncle. I know, as a judge, I know you have a strong case. If I see the facts of the case, it is true that there is a breach of contract and you have a right to get compensation. It is very evidently. And to come before me, will I take into consideration the fact that you have a strong case to recover compensation for extension of time, and I will take into consideration only sufficient cost. Sufficient cost means Usharlilva, why there was a delay. That's it. I will not take into consideration how strong the case is. I'll not go to the merits of the case. While giving what? Extension. Will I consider the merits of the case or only sufficient cost for delay? You explain just sufficient cause for delay. Delay ಏನಕ್ಕಾಗಿದೆ ಅಂತ explain ಮಾಡಿ ಅಷ್ಟೇ. ಸರ್ ನನಗೆ ಹುಷಾರಿರ್ಲಿಲ್ಲ ಸರ್, ನಾನು ಅದು ಮಾಡ್ತಿದ್ದೆ ಸರ್, ಇದು ಮಾಡ್ತಿದ್ದೆ ಸರ್, ತಿಂಡಿ ಮಾಡಿರ್ಲಿಲ್ಲ ಸರ್, ರಾತ್ರಿ ಬೇಗ ಮಲ್ಕೊಂಡಿಲ್ಲ ಸರ್. I don't care why you came late to the class. Give me an sufficient cause. If it is sufficient cause, I will allow inside the class. Otherwise, I will not allow. Door one, court is closed. Traffic is a sufficient cause. What cause? Sufficient cause. Just because you have a sufficient cause doesn't mean I will allow you inside the class. It's a discretionary power. What power? And just because I allowed one student inside the class doesn't mean I will also allow you inside the class. You cannot come and say, sir, ಏನಕ್ಕೆ ಅವ್ರಿಗೆ allow ಮಾಡಿದ್ರೆ ನಾನು allow ಮಾಡಕ್ ಆಗ್ತಿಲ್ಲ. Don't question me. It's my discretionary power. Which be go to High Court and challenge. Are you guys clear with this, everybody? So we discussed three section number. Section number 3, section number 4, section number 5. What is 3? Vara limitation. 4 closure. 5 sufficient cause. What cause? I will discuss one last section number 6, 7, 8. That's it, and we go. What combination? I cannot discuss separate. If I discuss separate, it doesn't make any sense. It is important also. ब्रेक चाहिए? कौन पूछता है भाई ब्रेक? I should not give. To start, names ಎಲ್ಲ ಹೇಳಿ ಅಲ್ಲ, at least at that time. Section number 6, 7, 8. Person under what? Legal disability. What disability? Legal. Bolo what disability? Legal. Law says. You guys tell me what will happen in this year. Let's not discuss what law says. You tell me as a person of intellect. You tell me what is the right thing to do in this scenario. I have a right to file a case today. Right to file a what? Case. On that particular day, I am legally disabled. Means I am incapable of filing a suit. Like I'm minor, I'm unsound mind, or mentally affected. Will that be taken into consideration? And will that be given as an exception for the purpose of limitation period? Why no? But the legal representatives, they'll not worry about this person. Huh? They may like, what if I don't have legal representatives? I may be having legal representatives, may not be having legal representatives. Even though I have legal representative, we don't have any good terms. Like, why will they care about me? My guardian is not so good person. Exactly. In that scenario, do you think this fact should be taken into consideration? Yes. That is why the law says on the day when the limitation period starts, if a person is in the legal disability, the limitation period for such person will start only when he is legally able. Till that time, limitation period will not start for him. The date on which, simple, listen, the day on which the limitation period start, on that date, if the person is suffering from legal disability, the limitation period starts to run only when that legal disability is removed. Disability is what? Removed. It means he becomes sound mind or becomes major. Becomes what? Major. Till that time, limitation period will not start for him. Limitation period will not start for him. I'll come to that one. Wait. He has not he has not become legally capable of filing a suit. He died being an unsound mind itself. Then the limitation period starts for the legal representatives. If a person dies before the legal disability ends, the legal representatives can file a suit within the same period from the date of death of the whom? Legally disabled person. That is when the limitation period starts for the legal representative. After he died, because I'll tell. I have answers for your question. Wait. Because once a person dies, his assets are inherited by who? Legal representative. आपको चाहिए बेका go file a case. बेडवा बिटक. If you don't want, leave it. Obviously, if you are going to get something, what you will do? Take an initiative and file a case. Logic है ना? Yes or no? Now, what if a person was under one disability? Means he was minor. Before he becomes major, he becomes unsound mind. A person who was suffering from one disability suffers with one more disability before the first disability ends. In that situation, the limitation period will not start unless until both the disabilities ceases to exist. Understood? What if a person was legally disabled, then he becomes legally able and he dies after 1 year? In that scenario, what happens? The legal representatives can file a suit within a what time? Remaining period of time. What time? Remaining period of time. Because limitation period already started. 1 year already over. They will get how many years of time? 2 years. I'll give one more scenario. Listen, everybody. Today is the cause of action. Limitation period starts on the date of cause of action. Cause of what? Is the date on which you have a right to receive it. On that date, you were solvent, sorry, sound mind. After 2 days, you becomes unsound mind. What happens in this scenario? Limitation period starts, it will not start. It will freeze or it will not freeze. It will not freeze. Once limitation starts, it will never stop. Section number 9. Once time stops, it will never stops, irrespective of disability or inability. Section 6, 7, 8 is applicable only in a situation where limitation period has not yet started. Are you guys clear with this? Because you had a time of 2 days, you could have filed a case. You did not file a case, so we will not extend the time. Court may take into consideration, it is a different thing. Section 6, 7, 8 is applicable only for a scenario where the limitation period has not begun to run. Not begun to what? Run on the date of December. This of what? December. Section number क्या है? 6, 7 and 8. 7 and 8 is different provision. First let us discuss section number what? 6. Section number what? 6. I want everyone to focus, and if you guys get any questions, get it clarified then and there itself. Which movie? Have you seen this movie? In Kannada also this movie is remade. So the Ucha, yeah. That is, it's the remake of this movie. Pagal, Pagal. This movie name is Pagal. I don't know whether it is name is Pagal, but I just then what is the movie? Kars. Sanam Teri Kasam. Huh? What is that? Kyuki. Cutie nahi hai. Kyuki. Kyuki. Wait. So is it sound mind or unsound mind? Simple. I just wanted to guys remember that if a person is suffering from what disability? Legal disability. What disability? Will the limitation period starts or not start? Not starts. So if they ask questions, they'll ask question based on this. I want everyone to read. I want everyone to focus, guys, for next for 10 minutes. Padhai karo. Let's start. Section 6. Bolo. 6, 7, 8 of Limitation Act 1963 provides relief to individuals who are under disability, such as minors and so on, ensuring that their legal rights are not adversely affected by their disability in terms of limitation period. First one. Disability before what start? Limitation period starts. How to present it in the examinations. Right? If a person is a minor, person is a what? Are mentally incapable, when the limitation period starts, they can file a suit or application after disability ends within the what time? Same limitation period. Means if a person was suffering from legal disability on the date on which the limitation period starts, then he can file a suit or appeal or application with the same time limit once the disability ceases to exist. Ceases to what? Exist. How you frame it, that is left to you. But these three keywords must be there. Disability on the date of limitation period starts. Limitation period starts only when the disability ends. These three words should be there in your answers. Yes. Criminal cases, there is no limitation period at all. No. Only if the offense is punishable with 6 months, 6 months, 1 year, 1 year, 3 years, 3 years. If it is an offense with more than 3 years, no limitation period. If three persons involved, the limitation period starts only when all of them becomes major. That is what section number 7. Next section numbers. I'll discuss that one. 5 persons. Okay. Good. Double disability. What disability? Did I discuss this provision? Yes. Just read one more time. If a person suffers from two disabilities at the start of what? Limitation period, or gets another disability before the first one ends, they can file the suit or application after both disabilities end within the what time prescribed. दोनों खत्म होने के बाद केस फाइल कर सकता ಎರಡು ಕೇಸ್ ಖತಮ್ ಆದ್ಮೇಲೆ ಕೇಸ್ ಫೈಲ್ ಮಾಡ್ಬೋದು. Next one. Death before disability ends. Then who can get the time? Legal representatives. If a legally disabled person dies before the disability ends, the legal representative may file a suit or application in the what time? Starting from the what? Date of death. That is when what starts? Limitation period starts. Second scenario. What is the third scenario? Legal representative of what? Under legal disability. Entire family only concerned. He is unsound mind. His legal representative also what? Unsound. Then when the limitation period start? When there is a legal representative who is what mind? Sound mind. He dies. His legal representative is also what mind? Unsound mind. Will it start? No. Then when he becomes sound mind, what starts? Limitation period starts. Right? If the legal representative of a deceased disabled person is also under disability, the limitation period begins only after legal representative's disability ends. What ends? Disability ends. Last one. Death after what? Disability ends. If he dies after disability ends, it already started. So the legal representatives can file a suit or within the what time? Remaining period. What period? Read. If a legally disabled person, what person? Legally disabled person dies after disability ends, the legal representative may file the suit within the what period? Remaining limitation period. Understood? Section number 6 not applicable for what? Appeal. Appeal के लिए appeal applicable नहीं होगा. Only for certain applications. Why? Because you cannot keep the appeal pending for so many years on time, right? Appeal not applicable. Keep this in mind. Section 5 applicable only for appeal. Section 6 not applicable for what? Appeal. Are you guys clear with this? Yes or no? Section number 7. Section number what? 7. Identify how many ghosts are there in how many couple ghosts and goats nahi hai bhai. How many couple ghosts are there in this picture? Seven couples goats jointly. Huh? Jointly 14. But if you count them jointly, in case of private company, what company? If the persons are holding one or more shares jointly, they will consider as how many members? Single. We will count them as single here. Jointly single. Single. How many ghosts are there here? 7. Which section number deals with joint persons? 7. Disability of one of the joint person. What person? What person? Joint person. क्या होता है if one of the person is legally disabled? There are two ghosts, joint person. Out of these two, one of the person is legally disabled. He asked this question, right? What happens in the scenario? Both of them or any one of them? Should be sound mind. Listen. That is when one person cannot give a valid discharge without the consent of other person. Means one cannot act on behalf of others without whose consent? Others' consent. But there are cases where a person can act. Concept, listen. If you don't understand concept, you'll not remember. It becomes headache for you guys to study. ಅರ್ಥ ಮಾಡ್ಕೊಂಡ್ರೆ things becomes easy. There are certain cases where one person can act on behalf of the other person without the consent of which person? Other person. And it is legally valid. For example, partnership form. What form? For the act of one partner, who is responsible? All the partners. Can one partner act on behalf of the other partner without his consent? Now, if the partnership firm is having a right to file a case, what to file a case? Right to file a case. What is partnership firm? All partners together. All partners are what? There is no separate legal entity. Yes or no? Out of all the partners, one partner is unsound mind. Can remaining file a case? Can give a valid discharge to her? Because of that reason, limitation period starts for whom? Everybody. Because one partner or one of the joint owner can give a valid discharge without consent of whom? Other, the legally disabled person. Then what starts? Limitation period starts for whom? All of them. But what if there are joint owners? What owners? Where one person cannot give a valid discharge without the consent of other joint owner. In that scenario, what happens? Limitation period will not start for both of them unless until both of them becomes what? Legally able. What able? Because I cannot act without your consent, na? And you are uncertain. Now, how will I file a case? Understood? Now you guys read this provision. Read. Read now. Where joint right, a joint right is inherited. Example, Karta can act on behalf of who? HF. Limitation run for everybody. Partner can give. But in case of joint owners of property, let's say X and Y holding property jointly. Can X act on behalf of Y without his consent? No, because there is no agency relationship. Then limitation period will not start for both of them. Only when a person inherits the joint right and where one of the joint owner can give a valid discharge without the consent of other joint owner, then the limitation period starts for both of them. Otherwise, the limitation period will not start unless until both of them are legally able or legally sound. Section number 7. That question will come into picture only when he is dead, deceased person. Yeah, then what happens? That legal representative should be what? Sound mind. What if he is also unsound mind? Then when he becomes a sound mind. Understood, everybody? Yes. Okay. Can you guys read this section number 6 and 7 restrictions? This is what most people. Section number 8. See, let's say a person was unsound mind for 20 years. How many years? Actual limitation period is 5 years. How many years? How many years? You should file a case within 5 years of date of cause of action. But on the date of cause of action, you are suffering from legal disability. Suffering from what? Legal disability. Law says limitation period will not start for you. So now you will become legally able after how many years? 20 years. Now you have how many years of time? How many years of time? No. Law puts a limit saying that only 3 years of time. If you claim the benefit of section number 6, section number what? 6 value, irrespective of limitation period prescribed anywhere else, we will not restrict the limitation to how many years? 3. You choose which one you want. If you claim the benefit of section number 6, section number what? 6. From the date you legally able, irrespective of the actual period of limitation, you get how many years of time? 3 years. Section number what? Section number what? 8. Now if you see section number 6 and section number 8, there is a conflict now. There is a what? Conflict. Section number 6 says he can file a suit within the same period as the legal disability ends. Then section number 9, section number 8 says no, only how many years? 3 years. Which one is correct? If you say 8 is correct, 6 becomes invalid. If you say 6 is incorrect, 8 becomes invalid. That is when the question of harmonious interpretation comes into picture. We have to interpret both in a situation where effect is given to what? Both the provision. How can we do this interpretation? So simple, say simple. The option is given to whom? Given to the legally disabled person. You decide whatever is beneficial to you. For example, let's say actual limitation period is 20 years. How many years? How many years? A person is legally disabled. Legally what? And he become legally able after 5 years. After how many years? If you go as per section number 8, only how many is available to you? 3 years. But as per the normal provision, 15 years. How many years? Which one you will choose? 15 years. I will say I'll not claim section number 6. I'll go with normal provision. You decide. Who will decide? Legally disabled person. But what if already 20 years over? That, that is the only option left. Got the interpretation of provision? Yeah. Same, yeah. Same thing. 6, 7, 8 should be read together. 8 put the what? Cap on the limitation period. How much you can claim once you become legally able. Legally what? Able. Are we clear with this, everybody? Restrictions on section number what? 6. Which act? Which section number provides the bar of limitation? 3 goes to closure of court, sufficient cause for the disability. Salman Khan, 6. Yes. His name starts with what? Yes, Salman Khan, legally disabled. Section number 6. 6 also starts with S only, na? Number 6. Yes. Seven is what liability. 7 is what? Joint right. What right? Joint right. 8 is what? Restrictions on section number 6 and 7. There's one. Okay. What happened to this? Are you guys clear with this? Can we discuss section number 9? See the heading, you'll get to know. Once time starts, it never stops. Once she starts, she'll never stop. She's the goddess of time. Uh-huh. Like just for if I say it in easy for you guys. Hello, concept guys. Discipline, guys, discipline. See, on a serious note, listen everybody. I don't know how many of you are serious of becoming a company secretary, but trust me, based on my experience and based on the students I've seen in the class, many students here only they have cleared their CS executive and they are doing internship in good reputed companies. Some other companies, good firms, listed companies. Don't think about what is going to happen after you become CS. कुछ तो कुछ हो जाएगा. Trust me, will some good thing will always happen. You become a CS. I've seen where a person would have said that bad thing happened because of CS. Something will happen. Obviously, good things will happen. But to experience that good thing, you have to put a lot of hard work, efforts. Many of you have the caliber of doing great things. But what I see, and I'm always a person who say the truth in the class. I don't hesitate to say the truth in the class because I'm not here to impress anybody. Many of you have that caliber to go beyond certain levels. The only problem is your laziness and lack of clarity and dedication. If you dedicate your time and efforts and discipline towards your study, believe me, you guys can achieve great things, many great things. Dedication is to be serious about the studies at the same time how to know how to enjoy the class. If I start focusing on only these things without concentrating on the concepts, it's of no use. We should know how to balance everything. That is when things keep your results as a paramount interest. What I've experienced by this time now. I was telling this even in the module 2 classes. Be serious, be serious, be serious. This is how the examination is going to be. Don't go with expectation. Expectation hurts, whether it is in real time, whether it is in examination. Don't expect. Go with preparation. Attitude ऐसा होना चाहिए कि आप पूछो भाई हम deserve to pass. Don't beg to pass. Prove, claim it that I deserve to pass. How can you claim it? Hard work, mehnat. There is always a scope for improvement. You have to improve as a person every day. Even I have a scope to improve. Am I teaching you the same subject with the same notes? Improvement. The notes which I have shared in the group. Material. That is the material which I have used last time. Student have scored 76, 80 by using that notes. Same material. And they were like, oh, acha hai, acha hai. Trust me, they were saying that. Improvements in. Improvise. Keep your results. And if you are claiming something, claim with authenticity. Give hard work. Even the God should feel like, okay, you deserve to pass. That is the effort. Sincerity. Go in detail, learn the concepts, and try to clear the examination as early as possible. How many days you want to spend in the classroom? Clear the exam, go to the practical world, start with your internship, get the practical exposures, and good things will happen. You have to earn it. You're not gonna get it easily. You should get these words CS with mehnat, hard work, and you are not inferior, not superior than any other professional courses. There are things which no other professional courses cannot do. We have exclusivity. Right, right. I know. Everybody know DNS, DNSS, ESA. We know because we are considered to be experts in law, interpretation of law. If you are considered as experts in law, then try to go in detail for every provision. As I said, anybody can have that motivation of clearing the examination 1 day, 2 day, 3 day, 4 day, 1 week. First week, I'll think like, yeah, sir, I will clear the exam. I'll become CS, sir. I'll study ICSA module, sir. Even I used to do it. I'll study ICSA module. But after a certain time, we tend to lose that motivation. That is what how the human mindset works. And your dedications and determination will come into picture only when you put that efforts or when you are consistent even in those days where you don't feel like doing anything, like days where you guys get bored on that day also if you sit and study and if so the same intent in the class are revise and come to the class. That is what defines you as a person, and that is what always contributed for your success. Aim for good things, clear the examinations. Every word, every concept you learn here will help you guys to get a good placement in the good firm at reach heights in your curriculum. You're not learning something which is nonsense, which will write exam and will forget everything. You're gonna use this in the practical life. So pay attention in the class, learn and be regular. Take things serious if you really want to be serious. If not serious, then you guys decide. If you are trying to, you have to claim it. You have to earn it. And I'm happy with the response you guys are giving. All of you are participating. The small things like you guys are like coming here to the class and other things. Make sure you guys correct those things, and so that we can finish this subject with a good note, which will help you guys to get that confidence of clearing the examination with good marks. And as usual, after June, we will be in a practical world. Short journey, then life goes on, correct, right? And what stays with you guys? CS, not CS, not anybody else. And what you learn here. And if I've taught something good, if I've done good things, you'll remember me even after you go out of this institute. And you'll remember me only if I have helped you on the day of your examinations. Nothing else. Trust me. Getting it? Let's take or keep results and studies as a paramount interest. At the same time, हम हंस के पढ़ाई करें. We'll enjoy and study, not with stress. Yes or no? Done. Chalo, thank you Salman ji, and I don't have intention to hurt anyone's feeling. This is only for education purpose. Viewers discretion advised. I'm not here to hurt any fans' feelings. Please excuse if anybody gets offended. Even to the booths also. Booth ji, please forgive me. Don't come in my dreams and smile. Chalo, thank you. See you guys tomorrow exact 8 o'clock.